Senator Ori, Senator Hembree, what purpose do you ask?
Thank you, Mr. President. To see if the senator from Beaufort would yield for a few questions.
Senator yields for questions.
Thank you. And Senator Davis, I hope you know and believe that I genuinely appreciate your patience with the questions. It's a complicated bill, and you've been exceedingly patient, and I greatly appreciate, I hope you know, the continued patience you have with the questions that I'm about to serve up.
I get the sinking feeling that that's a preamble you give to somebody you're going to destroy on cross, right?
As you know, as a lawyer, when the judge starts out saying how good a lawyer the defendant has right before sentencing, that's a bad day for the defendant. But truly, the questions I have are fairly confined, so I don't expect to be keep you up there with my questions for very long.
Do the best I can.
Couple of subjects that I want to touch on, because I'm just more than anything else a little confused as I've repeatedly studied on the bill. And I want to first talk about the revenue that is generated by this article, by this bill and this proposal. As I understand, it creates on page, I'm going to go to in 4453 2020 section A.
I'm sorry, sir, which one? I'm sorry,
4453 2020A.
2020A. Sorry, let me get to it real quick.
Sure.
Section 44-53
2020A.
2020A. Sorry, I went to the wrong section. You know what page that's on, Senator? I'm just
on my Senator, on my copy of the bill, it's page 8, but okay. I'm not sure which.
Okay, I got it now. Yes, sir.
So as I understand, the DHEC under Section 8 would establish a South Carolina Medical Cannabis Program Fund, and that all monies collected pursuant to this article must be deposited into that fund. Is my understanding correct about that?
And that's correct.
Okay. And the money that is not spent out of that fund, so the leftovers, if you will. Now the revenues, and follow along with me in B, just to make sure I'm tracking with you. I guess I want confirmation that I'm understanding it. That the revenues generated in excess of the amount needed to implement, administer, and enforce the article. Okay, that's revenues in excess. So I guess the implication there is this fund is to be used for implementation, administration, and enforcement of all of the components of this program.
Correct.
Okay. And the excess above and beyond that might be generated is split up in the committee amendment.
3% to
3% to MUSC, 2% for treatment,
3% to SLED.
3% to SLED. Let me ask you a question about that.
Okay.
Does that 3% to SLED, that's not contemplated in the enforcement? I mean, SLED would get money for enforcement of this program out of the fund on the first cut, basically, out of the fund before you start splitting it up. Or is it your intention? Is it your intention and your understanding that to enforce this and to carry their responsibilities out, all they get is 3%?
No. The argument would be that when SLED comes forward during the budgetary process and makes the case to the subcommittee as to what funds they need to carry out and enforce the laws of South Carolina, that included in that budget fund request take into consideration if they received any money here through this program, because obviously that would be credited against the amount that they need, and so the rest would come from the general fund. But I have no doubt that in the immediate future, a lot of it's going to come out of the general fund. But it's my expectation, based on other states' experiences, that the revenues generated over time, that 3% then becomes a substantial amount. Whether that's sufficient in order to compensate SLED for what it needs, you'd have to wait to a budget hearing to establish that.
So I guess then that I guess is confounding a bit. All right, it's inconsistent because is it not that in B it says for the enforcement revenues in excess of those needed to enforce it go to these different entities?
No, because the revenue that you're talking about there, this medical cannabis fund, that defrays DHEC. DHEC is the one in charge of this program. DHEC licenses the medical cannabis establishment. DHEC is the one that licenses the independent lab inspectors. DHEC is the one that issues these registry cards. DHEC is the one that carries the administrative burden here. And that's what we're talking about in terms of DHEC's costs in administering this program, okay? What this relates to, what you're pointing to is, okay, after that's been done, after DHEC has been made whole, DHEC doesn't need any more money, I'm specifying where those excess revenues go. To your point, am I saying that that's all the money SLED is going to need in order to discharge or carry out this law? I don't know.
Right.
It depends upon what SLED's actual needs are.
Right.
It depends on what sort of revenue is thrown off by that 3%. I don't know. So, but that's my reading of that.
And you've got their estimate, but you don't have confidence in that estimate. You've expressed that earlier.
And I guess, yeah, the short answer to that is yes. I honestly don't, given the number of medical cannabis establishments, the limited number in this bill, I consider them to be limited in nature. And given the fact that the administrative burden of administering the program is given to DHEC, I don't know on what basis, I'd like to see it, where SLED says it needs 78 new employees to establish 2 new cannabis units. I mean, I haven't seen their presentation. That seems, compared to other states, and I've checked, and the adjectives used to describe that have been ludicrous to outrageous. But I'm open to listening to why they think they need 78 new employees.
And so assuming that DHEC uses a substantial amount of this money, and the rest gets split up, and SLED gets 3% of that total, they'll also, I mean, it seems likely that they will be requesting general funds above and beyond what they may get out of that 3% that's a percentage of something else.
I don't know, because I don't know what that 3% is going to be in monetary terms, and I don't know how you go about in terms of saying, okay, we're going to enforce all these laws we have in the Code of Laws, and their ability to section out by saying this particular aspect of the law is going to cost us this. I don't know if SLED's ever done that. Does SLED allocate or make budget requests? And I'm honestly asking the question. Do they make budget requests and then monetize each section of the code that they are to enforce? Is that how they break down their budget request?
I can't answer your questions,
I can't either.
But let me go. Let me keep moving on.
Yep.
I get, at least I understand, and you've answered my question. It's your intention that that money would be used for enforcement on their side of the enforcement house that they may be called upon to do in this bill or otherwise.
And I would also say this. I would not take that language to mean that they're precluded from coming before the General Assembly and asking for additional appropriations if they can make that case.
And isn't it true there's 85% of the money going to the general fund, so they could be dipping into those funds in another form. Could you explain to me the 2% for treatment, what your thinking was on that with, obviously we're launching into a very, I guess, progressive field here, so to speak, not field, but program, that there is a lot of fear and concern that this may lead to increased drug abuse in South Carolina. Yet 2% to help those, which may be, it depends on your estimates, and we can pull out you can pull out a study, and I can pull out a study, we go back and forth, but, if there's 20% of people that become marijuana dependent as a result of this and need treatment services, that's a pretty big number, is going to be a pretty big number. Do you genuinely feel that 2% is sufficient to cover those needs that are inevitably, for some, going to be real?
I'm not wed to that figure. If you feel like more of the excess funds generated should be allocated to that, I'm open to that. There's no magic to those numbers, Senator.
And the 5% that goes to MUSC to do permanent, 5% for research, to really test the effectiveness of cannabis, and really expand the use of cannabis, essentially, to do research to expand the use of cannabis for other illnesses and maladies. That number, I guess I'm trying to figure out where these numbers came from, because my concern, I will say, is you get 2% for treatment, and you got 5% over here to try to find new markets, essentially. You to try to expand the market, because you can find new diseases and you can add them to the list. Then you got more business. It's a good marketing program to have the public pay for it. So help me with that. How these numbers got calculated.
In terms of looking at what some of the areas we needed to be cognizant of, it seemed reasonable that some of the money be given to those involved in alcohol and drug abuse. It seemed reasonable to have SLED get a revenue stream. It seemed reasonable to provide some money to the Department of Education for drug safety education. It seemed reasonable to give 5% for the research, to the Senator from McCormick's point about research is important. I'm not wed to any of those figures. I mean, they're not, platonic truths here. I mean, we can make those numbers whatever we want those numbers to be.
Over on page 9, under 4453 2030.
Hold on, let me get there.
Sure, it's one page over.
22. Say it again, sir.
4453 2030.
Okay, gotcha.
This allows DHEC to implement a reasonable fee increase to be charged and collected pursuant to the article for the department to cover the cost of administering and operating the program pursuant to the article. So as I read this, and help me understand, as I read this, they can charge a fee to whomever they charge fees to in connection with this law to pay for 100% of, it would pay for 100% of the administration of the program by DHEC.
It was meant to give them plenary authority in that regard. And to your point, I guess what you're saying is, does that somehow mitigate against the generation of funds that would go to those groups, the surplus funds? I mean, is that what you're getting at? Did this somehow?
The way I will let me rephrase my question. Maybe the way, or did you know that I read that to say they can charge fees that are nondescript, doesn't tell you where they're getting them from, it's very, very vague, but they are permitted to charge fees sufficient to pay for 100% of the program. Right. Therefore, then every other dollar they collect, aside from those fees, which pays for everything, would go into this split. Because essentially, you'd have this pot over here based on their fees that pays for the program. Then you got this pot over here that's in excess of, in the previous statute we talked about, the previous section we talked about, in excess of, and so that's 100. I mean, all that money is going to be in excess other than these fees. Is my understanding correct?
I take the point that you're making, and I can just tell you what my intent is. My intent is that DHEC have the ability to levy fees, which, coupled with the sales tax revenue they're going to be getting, to levy fees up to covering the full amount of covering the program and no more is my intention. It's not my intention to create an open-ended thing to where they can actually be generating and it may be that the sales tax is going to generate so much revenues that we need to either consider taking the sales tax off because it's being covered by other fees in the program. But I was really anxious in drafting this to make it self-sustaining. I didn't want this to be, in the long term, something that had to be funded out of the general fund. I wanted it to be almost like with the user fee with the gasoline tax. I mean, those that are accessing the program, those that are getting the medicine, to try to allocate the cost both on the patients who are doing that and on the medical cannabis establishments that are growing, processing, and dispensing, and those who are inspecting and transporting. So that's the idea here, is to try to avoid an impact to the general fund. And if I've done so imprecisely, then I'm happy to try to clean it up.
So my next question is on section 4453-2040A. In addition to the fees that DHEC can charge to pay for the program, there's a 6% sales tax charged on all sales of marijuana at the point of sale. So I'm going to assume that's dispensaries and not. Are you charging a sales tax from the grower
No,
to the,
it's at the point of sale to the patient.
And all revenue collected pursuant to that tax goes
in that
back
fund.
into the fund,
The fund.
as well as the fees go back into the fund, because everything you collect under the article goes back into the fund.
And then 85% of it goes into the general fund. So that's sort of like the flow that's anticipated here. But again, I'm not wed to any particular language. My overarching objective here is to make sure that the costs of administering the program fall upon both the medical cannabis establishments and the patients, and that it not be something the general fund finances. That's my objective.
So let me jump up to my page 15, section 44532100.
Yes, sir, I got it.
Okay. And I'm jumping down to sub 3, sub A.
Yep.
And there, once again, DHEC is allowed to charge the patients, the qualifying patients, non-resident card holders, and designated caregivers a fee for the cost of processing the applications and issuing the cards.
Right.
So that's would be considered a separate fee. But I think it's the way it's structured, it can only be used, or actually be used to pay for the actual processing, the staff time it takes to process the application, and the staff time it takes to generate the card and get it out the door to the patient, designated caregiver, or non-resident cardholder.
Right. It can't be any greater than the cost of processing and issuing the cards.
But I again would assume that this fee goes back into the fund. Mm-hmm. Right. Let me take you to 18.
Sir.
And there's a fee that can be charged there for the same kind of thing, I suspect. But is it my understanding that the
What section is that, Senator? I'm sorry.
Let me see here.
Or subparagraph. I'm in the vicinity. If you just give me the number of paragraph.
This is in B.
Okay. B. Okay. Got B.
And
Okay. Subparagraph 1A. The application or annual renewal fee set by the department.
Okay, once again, it's just another renewal, an application or renewal fee that can be charged by the department, goes back into the fund.
What I tried to do, and I take your point, is I'm trying to give plenary authority to the department in each of these instances to levy fees to cover costs. And again, the ultimate objective, policy objective, is to not impact the general fund.
And let me take you over to the following page 19. This is going to be in section, well, it's toward the bottom of the page, section C. Is that how yours looks?
Yes, I got it. Mm-hmm.
Mm-hmm. This is
So the department shall deny, suspend, or revoke? Is that
right?
Language? Okay.
You have some, here we go, I'm sorry. You have some criminal penalties. Let me just ask it this way. You have criminal penalties in numerous sections. Instead of just dragging you through them, it doesn't serve any purpose. You have criminal penalties in numerous sections of the bill for a host of different, criminal acts.
Misrepresentations.
Could be. There's some 500. There's a fee. There's a fine, a civil fine. I believe, if you don't change your address, if you don't notify the department, you change your address, you're subject to a $500 civil fine. But you also have some, and civil fines, those would go back into the fund. That's a little different than a criminal fine. However, the criminal fines are subject to an entirely different sort of body of law that divides those things up and sends them wherever they send them. And I guess my question is, was it your intention to have those criminal fines directed into the fund, because those criminal fines are part of the article, their money's generated by the article, yet they're going back into the fund if I read your proposal correctly?
No, to the extent that it's not clear, criminal fines, it's not my intention to supersede existing law in regard to where criminal fines go. And you would know better than I as to where those monies go. But it's not my intention that those criminal fines supersede existing law in regard to where they go.
So that section may need some cleanup. All of those criminal sections could need some cleanup.
And to your point, and in regard to these instances where I say DHEC can charge fees and try to break it down, maybe some more clarity can be had in regard to the nature of those fees and some more precise language drafted. And I'm happy to work on that.
Thank you. Page 48, there's, let me get to it. Bear with me, Senator, I'm sorry.
Sure, no worries.
There in section, it's on page 48, it's subparagraph D, just about a quarter of the way down.
And that's in what section? 44-53-2400?
It's 4453 2400.
2400, okay. D,
Paragraph
got it. Okay,
D.
got it. Mm-hmm.
And this again, I know it's tedious, but I just want to get my clarification.
Sure.
Establish and charge an inspection fee in an amount to be determined by the department that will cover the expense of the department for conducting an inspection. So, is it your idea that every time DHEC goes into a production facility or a dispensary to check on things, much like they do with restaurants, if you think of it like that, doing a restaurant inspection, that they go in, they do their inspection, and they can essentially present a bill or charge back against that business the cost of that inspection?
It is. Again, the objective here was to try to allocate or distribute the cost of administering the program among the participants in that program.
And on page 49, you kind of get into the local government, land use, and I'm going to go with, I'm talking about 4453, 2420, section D.
I'm sorry, 2420 section what?
Section D.
I don't have a D in that section. I think you want to do the next one, 2430.
Oh, I'm sorry. You're correct. I apologize.
Okay.
2430, section D.
Right. A local government may not impose any tax or fee for the sale of medical cannabis products sold in the dispensary.
Right. My question is, the way I read that, they would not be allowed to charge a business license fee that is based on their gross sales. Is that your reading of it as well?
It is. That's the reading. No tax or fee, so that will be inclusive of business license fees.
I mean, was that your intention to exempt medical dispensaries from?
To be frank with you, that's the first time I ever thought about it being a carve-out from the business license fees, to be honest with you. The objective here, the intent was that I didn't want this to be a revenue raiser for local governments. But I guess the point that you're making is to the extent that it takes its place alongside other business operations throughout the state, it may be equitable to have them be treated the same way. And that's a fair point.
Just might need to clean that up some too. And then on page 54, and I'm going to take you to section 4. That's on my page 54.
Section 4 of the bill?
Correct. Section 4 at the top. And it says 69, and it says cannabis sold by a dispensary to a cardholder pursuant to this chapter. And isn't it true that, correct me if I'm wrong, but isn't it true that what that provision does is it exempts marijuana dispensaries from paying sales taxes? It puts them on the exemption list. So over here, we're charging 6%, and yet over there, we're saying you don't have to pay the 6%, and it's just kind of, I mean, see the reason for my confusion.
And I picked that up in reviewing for this debate, and I think it's the amendment we may be on right now, which deletes that, because you're right, there's an inconsistency between establishing a 6% sales tax and then referencing a provision that says you're exempt. And so, again, that was on the desk the first day. But you're right to point out that that is an inconsistency.
And that's all the revenue questions I have. I think that's kind of covers the waterfront with the concerns I had and some of the cleanups that appear to be wanting in the bill as it relates to revenue.
Yes, sir.
Explain to me, and I looked at page 55, and I'm looking at section 8 now.
hold on, let me get there.
Just walk me through how this thing, because you've got at least 2 computer systems, the best I can tell, that you've got to set up. At least 2, and there might be another one in there. And you've got forms that have to be generated. You have regs that have to be adopted at all levels for dispensaries, for production facilities, for processing facilities. You have to come up with a security. SLED has to come up with a security plan for everybody's business, essentially.
No, no. Each establishment comes up with a security plan in consultation with SLED.
So, right. But I mean, security. Yeah, I'm sorry. Right. But SLED has to be.
What section are we on?
They're engaged. Well, I'm getting you to section 8, and I'm kind of laying out all the many parts of this bureaucracy that we are establishing with this bill. And I'm curious. I'm having a hard time following along exactly when it goes into effect.
Okay.
I know that there's a part in here, if I understand correctly, that if it don't have it up and running by 2 years, then somebody could bring suit and sort of I guess a writ of mandamus or some sort of suit like that to force them to get off their backside or quit dragging their feet. But I get that. I mean, I understood there was sort of this drop dead at 2 years, but other than that, it seemed a bit all over the boards, and I was wondering if you could sort of walk me through.
Yeah. Let me take a look here. Okay, so after the effective date of the act, which would be when the governor signs it or whatever, when it goes into effect, that they have to create a commission, the commission we talked about, within 30 days. It talks about their obligation to develop a written certification form, which is the form to be completed by the physician in authorizing the use of cannabis no later than 10 days after the effective date of regulations that have been promulgated. It talks about those regulations to be promulgated to be no later than 1 year after the effective date of the act. It then talks about DHEC's obligation to engage a company to create the necessary software for an electronic patient registry no later than 120 days after the effective date of this act. It requires them to develop the safety information flyer, no later than, which has to be available at the point of sale so that patients get them, no later than 10 days after the effective date that regulations are promulgated, and to establish a secure web-based verification system within 1 year of the effective date, and then promulgate regulations pursuant to Section 44-532350 no later than 1 year, begin accepting applications for licensure no later than 30 days after the effective date of the regulations. And so I guess the question is, how do we come up with those dates? How do we come up with those times? And as best I can recall, in talking with DHEC, and DHEC provided some feedback in regard to what it thought were reasonable times, and we started from that and worked from that. To be honest with you, Senator, I don't remember whether we materially altered what DHEC had sent to us or whether I just simply took them verbatim. I need to go back and check my notes on that. But it would have been, as an initial matter, asking DHEC, okay, these are all the things, and they went through this act, and much of this act was kind of drafted by their attorney. And so I asked them, I said, okay, this contemplates you doing various things. Give me an idea of the time that you would need. And that was the point of departure for getting this. But I need to go back and see whether or not we took what they sent us verbatim or whether I adjusted it.
So I should ask DHEC?
Now you can ask me, and I'll find out what my notes are in regard to what DHEC provided and how this bill ultimately turned out.
Okay. And I left one of my revenue questions out. I just recalled. This has to be a cash business, correct? That's my understanding. It's not.
No. Okay. The Department of Treasury, and let me be precise here so that I don't want to talk in generalities about something that's that important. My tabs are getting bent, so okay. The United States Department of Treasury has what's called a FinCEN division, which is an acronym for Financial Crimes Enforcement Network. And FinCEN, I'm going to read from its promulgation of guidelines to marijuana-related businesses. They provide guidance to clarify how financial institutions can provide services to marijuana-related businesses consistent with their BSA, and BSA is Bank Secrecy Act obligations, and aligns the information provided by financial institution in BSA reports with federal and state law enforcement priorities. This FinCEN guidance should enhance the availability of financial services for and the financial transparency of marijuana-related businesses. So FinCEN, Division of the Department of Treasury, promulgates guidelines that banks and credit unions have to follow if they want to accept deposits from cannabis-related industry. And there was a recent case, I think about earlier this year, maybe late last year, or last year or the year prior, where there was a credit union, for the first time, really, that Treasury came down on them and fined them for taking deposits from marijuana or cannabis-related industry and not following these FinCEN guidelines. So that having been said, it's expensive to comply with that. You have to hire attorneys, you have to hire accountants. There is a layer of cost associated with taking deposits from cannabis-related industry. And that's why you've seen such a push at the federal level to modify federal banking laws so that these particular FinCEN requirements were no longer in place. But it can be, you can use these financial institutions that follow these guidelines. And to be frank with you, many of the institutions decide not to do it because it's financially prohibitive. And I want to be transparent about that. It is an onerous thing, but it can be done.
So in practice, in most states, this is generally a cash business.
I think it's fair to say that because of those constraints, the number of financial institutions participating that you have, but that's not the case with, like, for instance, a friend of mine in Maryland. We went up to visit his dispensary. He's got a bank that he has a relationship with, so he does use banking. I don't know the percentages, but it's fair to say that for many institutions it's cost prohibitive, and so the medical cannabis establishment does have more of a cash component to it than other industry does.
And they can pay their taxes in cash. I mean, there's nothing, they can pay taxes, and they do pay taxes to the federal government, to state government, and certainly cash is an acceptable form of tender still.
Yeah, and even there, though, Senator, the guidelines that have been issued by the IRS, there are certain restrictions on what medical cannabis establishments can do in terms of cost of goods sold, deductions, and whatnot. They're treated differently by the IRS, but the IRS issues those guidelines, and of course, cash is always a good
Certainly.
medium of exchange. Yeah.
So I guess I was curious, what do you contemplate as the dispensary has all these fees, fines, whatever, inspection fees, taxes, and they walk down to DHEC with a sack full of money? Is that how this is going to go?
I don't know if they walk with a sack. Maybe they use a briefcase.
Fair enough.
I would think, again.
I was thinking about some of my clients. They use a sack full. They use a little sack.
I would like to see it easier for credit unions and banks to participate in the cannabis industry. They can, and there are guidelines issued by Treasury. To your point, a lot of those requirements are expensive, and a lot of institutions choose not to do it. But many do.
Yeah, and I get that you would like the federal law to change. I understand that, but that's not where we're living, and that's not what, as we look at the consequences and the practicalities of this proposal, isn't it true that we have to look at where we live, not where we would like to live?
Yeah.
So I guess my question is, they're going to be have a deposit cash with DHEC. Is that what you foresee? And these are going to be startups, true? All of them will be startups. So
unless they have a relationship with a credit union or a bank, which they can have.
Correct.
If they choose not to do that, they would have to get those monies to DHEC in another way.
So if this money that's sort of federally illegal, for lack of a better way to describe it, it's tainted in some way, gets to DHEC, then when it becomes DHEC, does that sort of wash the taint off of it? Or does DHEC have to figure out how to deal with this cash?
All I can tell you is in the 36 states, 37th was just last week, so I don't have it set up yet. The state agencies have been able to receive the fees in a way that was not complicated and did not result in disgorgement. and didn't constitute money laundering. So I can only point to the experience. And again, we're not creating something out of whole cloth here, okay? We have the ability to look at what 36 states have been doing for a long time and kind of draw some lessons from that. And so, I mean, I understand what you're saying, that somehow this being a cash business because of the difficulty of accessing financial institutions, that there's going to be somehow tainted money that's going to complicate things for state agencies. All I can say is I've not seen that as being the experience in the states that have medical cannabis.
Okay. Well, did you contemplate putting, including a section in your bill that addressed that issue, that provided, DHEC, instead of them sort of standing there going, well, I wonder if can we take it, can we not take it? What does the federal government say? I mean, we're putting them in, it feels like to me, we're putting them in a very vulnerable position for a state employee who's making, $35,000 a year to try to sort all this out. Did you consider adding something like that into your bill that would pattern another state? Or?
Yeah, I haven't, but I take your point, and as I've done throughout this debate, when I think valid points are made, I'll sit down and figure out if there's a way to not only clean up the fees to the extent that there may be some ambiguity there, but to maybe specify the remittance of those fees or to establish some protocols or discuss that. I mean, I think that's a valid point you're making.
I appreciate your patience with me, and thank you for responding to my questions.
Thank you, Senator. Okay, that concludes my remarks. I appreciate the opportunity to
Mr. President.
for you.
Senator from Ori, Senator Hembree, what purpose do you ask?
I'd like to speak on the bill.
Let's publish. We need to publish the First Amendment first, then I recognize the reading clerk will read.
Amendment number 1A is by Senator Davis, amends the bill, page 54, lines 4 through 8, strike section 4 in its entirety.
Senator from Ori is recognized. Senator from Ori, Senator Hembree, what purpose do you ask?
Speak on the bill.
Speak on the amendment. Speak on the amendment. Is recognized. Senator is recognized. Senator from Ori.
Thank you, Mr. President. I've got a lot to say about this bill. But before I do this, I want to share a thought with my fellow senators. I think sometimes, I know for myself, I think sometimes that we don't fully appreciate the gravity and the weight of the job that we have. We come up here 3 days a week and we kind of sail from one meeting to the next, and we do it for a while, and it starts to sort of see, there's a routine that develops, and there are friends and relationships that develops, and there's a pattern to it that develops. And it sort of feels like, we're just kind of doing a job. We're just carrying this out. But every once in a while, I think it's really important for us to stop and think of what our fellow citizens have entrusted in us. It's not routine. They're trusting us with their very safety. They're trusting us with the safety of their families and their friends. And they are counting on us. They are expecting us to do right by them. And they are counting on us to do things and make decisions fully informed, thoughtfully considered, with their best interest and safety at heart. And when we say, and we make that decision, we put the stamp of approval of the General Assembly, the South Carolina Senate, the South Carolina House, and the governor of South Carolina, that citizen is going to feel confidence that what we have told them is true, that what we have told them is safe, that what we have told them will make their lives better, not worse. And that is my problem fundamentally with this concept. Because, I've said this before, if we were debating recreational marijuana, I would feel a lot more comfortable. I wouldn't vote for it, I think it's a bad idea. But I would feel more comfortable, because we wouldn't be talking about this is going to be good for you, this is going to make you healthy, this is going to make you better. We'd be talking about a dangerous substance like alcohol. We'd be talking about a dangerous substance like tobacco that we've decided we're going to make legal. And we'd be able to tell our citizens, look, this is a bad idea. There are all these health problems that are real. That's one of the problems with this whole thing. You've got some people it helps, and you've got some people it ruins. And it's all over the boards. That's why the FDA hadn't come out, except for 4 drugs, but they haven't come out and said, oh, we've got it all figured out. That's the conundrum we're in, because it's dangerous for a lot of people. So, I'm not comfortable. I would be more comfortable then, because if we did it recreationally, then we could say, look, we're putting a label on this thing. It's bad for you. Don't do it unless you just want to. But you understand you're on your own, okay? You're a free citizen, state of South Carolina, you get to make decisions like this. But what we're doing with this proposal is we're sending a different message. We're saying something else. And I'll get into the doctors later, and we'll talk about that some. But the ones that we have promised and pledged to take care of and look out for, they are going to hear us say, yes, it's okay, and that's where they're going to stop, okay? They're not going to go through all the studies. They're not going to do all this digging and like Senator Davis has and like I have and many of you have already done to look at the good, the bad, and the ugly. They're just going to say, well, the government says it's okay. The government says it's medicine. Medicine is good for you. Medicine is good, right? Medicine is good for you. Medicine makes you better. Medicine makes you healthy. The state said so. And for us, as politicians, as public servants, put it that way, as public servants, for all walks of life, all sorts of jobs, all sorts of expertise, okay? For us to step into the shoes of the Food and Drug Administration, who has that responsibility, we rely upon them all day long, doctors rely upon them, patients rely upon them for many, many years, for us to say, you know, we're really better at this than you are. We don't like the answer we're getting from you. So we, being the South Carolina Senate, with our vast experience in evaluating effective medications for patients, we're going to tell the folks back home it's okay. I can't believe I'm even having this conversation. That seems so crazy to me. It's like I just sort of talk to myself, going, what in the world? I mean, who thinks that? You know, is there anybody in here who thinks they're smarter than the Food and Drug Administration? Of course not. Wait. Senator. Let me make.
He refuses
shift
to yield
gears
at this
so
time.
let me shift gears. I want to let this body know. It's a 57-page bill. I've read it and read it and read it. There are lots of little pointy parts to it. Lots of questions, lots of problems. I'm going to review those problems with you. It is going to be tedious. You're going to be tired of hearing me. I'm almost now tired of hearing me. But it's important for you to hear it. You need to learn it, because I know some of you have read it all the way through. Every single word, studied it, not just read it, studied it, thought about it, contemplated it. And you know where you are, okay? You've made up your mind based on what you understand in this bill, and you're one way or another, and that's okay. And if you're there, maybe you can go on out and get some dinner, because that's probably a good idea. But if you're not, or if you haven't contemplated each and every paragraph and each and every line, then I urge you to be patient with me and let me do that with you. I'm not going to take any questions at this point. I will go through the entire bill. After that, I will avail myself to the questions that come from the body. So I'm happy to do that. I respect Senator Davis' willingness to do that, for a very long time. And what's good for the for the senator from Beaufort. It's good for the senator from Moree. So